So this is the Chillie trial coming up on December 6th. We know it'll be continued based on my last video, looking at the docket. Now I'm looking at the videotape, the body cam from the arresting officers. 5 cops showed up, and the short answer is, based on the resisting and obstructing charges, I say that Chillie will most certainly be convicted of one of them, if not both of them. The problems with the statutes in my book is that they're not constitutional. But what do I know? The Nevada Supreme Court has already ruled that they're constitutional in a split with the Ninth Circuit. So if Chillie wants to go the route of playing it out for the guilty plea, even though he's trying to get obviously acquitted, the downside is he gets 2 more misdemeanors potentially on his record. The upside is that there's not going to be any jail time for him. From what I've seen, the pattern in practice is to give them no time, but to put them on probation. He said, for a solid year, I was nice. I'm paraphrasing. I was peaceful about this. And I talked to the corporals, the lieutenants, whoever. And so that means if I was the prosecutor on this case, I would say, okay, so what you really have said now is that after that 1-year self-imposed deadline has ended, you now are at war with the cops. Now, under that premise, the obstructing and resisting charges, they fall in real nicely now, don't they? We'll see that he has a number of times where he's told to put his hands behind his back. That would be an obstruction. That would be a delay, according to the cases. Then we have the resisting arrest. From the cop said specifically, the resisting arrest charge came from when he tried to physically restrain Chillie, and Chillie's movement away from him switched off the cop's body cam. And the cop was saying that he had to put it back on. He also said that he's not some, frauditor that makes a lot of money off of YouTube videos. He's not in there for the clicks and something like that, which was kind of hilarious. There's a lot of tape to watch, and I can't play it all because it would just be forever. So this is, of course, behind me is playing is the clip of one of the arrest videos. So let's take a look.
Back up. You're not.
Okay, so that's 3 years. He's coming into view. He's filming the cop directly. These are courtesy of Artie's Corporate Fiction. Thank you. That's the car that was pulled over.
Don't engage my driver. Back up.
Lawful orders to back up.
Involved. Listen. You can film, but you need to stay away from my driver. Back up.
Court time. Now, as you know, DMA audits, when he got convicted in federal court, one of the things he got convicted for, one of the grounds, is lack of privacy for the people who visited the Social Security office, and his filming could reach into where the people are at the counter, potentially recording private conversations or private documents. Same thing here with him recording her directly. If the cop had her driver's license or whatever, he's now imposing himself right in the middle of that and making, a recording of it. So the cop is basically saying, if you just get far enough back, you could film all you want, but that's not something that Chillie's going to prepare to tolerate.
Back up or I'm going to detain you. For obstructing. Get away from my car stop.
Chillie says he's a constitutional law scholar. Again, he continues to ignore the fact that he is about to be detained, which means he's not free to leave.
Okay. Do whatever you want. Listen, she deserves privacy. This is not your business.
I'm a member of the press. Go get in your car and do your job.
Okay.
So he said, go back into your car and do your job or something like that.
You're being detained right now. And you're free to go.
Oh, you're gonna...
Now, I admit that is pretty funny. He's dismissing her because his work with her is done, and now Chillie is on his way to being arrested, although he's not arrested yet.
Come over to my car. Come over.
This would be either resisting or obstructing, but he's not touching the cop.
Over to my car. Come over to my car right now.
That would be obstructing. We're delaying the situation.
Come over. Listen,
don't put your fucking hands on me. That sounds rather confrontive, combative. We're getting closer now to a resisting arrest charge.
I'm going to put my hands on you.
No, you're not.
That is resisting arrest. I'm going to say it right now. In my book, if it were up to me and I was acting as a judge as fairly as I can, because remember, I'm trying to be fair here to Chillie. You have to be fair. You have to be objective. That to me is resisting arrest. No, you're not. Well, what else is it? You're not agreeing. And the look and demeanor of him, this is confrontational.
Control 3 Robert 1.
I gotta make sure.
Yeah, the cops radioing in for another squad car, so he's definitely going to jail.
Hey guys, make sure you guys get my people on the phone.
Get my
I have
people
an
on the
obstructive
phone.
male here who's filming me.
So you ended the
Okay, that word triggered Chillie. Obstructing. He knows that's a criminal offense. Now he's going to plead his case.
stop.
Come over here to my car. Come over here.
Obstruction, lawful orders.
I need additional
Bring your
units.
supervisor,
I need this obstructive.
Cop said he is obstructive, need additional units.
Bring your supervisor, please. Don't
Come
touch
over to the car. I am gonna
This is resisting now. He's like, don't you touch me, don't you come near me, that kind of shit.
grab you.
Don't
You were
grab
going to go
me.
to the
Don't
ground.
grab me.
This is resisting arrest, guys.
Listen, you
You're
are
not-
detained right
No,
now.
first get your supervisor out here. You're not just
I don't
gonna
need a
grab
code
me and
red,
throw
but
me on
he's
the ground.
arguing with me. I just need additional units.
Cop says, I don't need a code red, but I just need additional units. So I think the cop knows he's not a threat as much as he is going to be an aggravation.
This is 2015 Rodriguez versus United States.
Come over to my car.
I'll walk right in front of your car.
I
Let's
am
go.
Okay, that's somewhat cooperative, but that doesn't erase what just happened.
Officer Bork, you're being detained for obstruction.
Now, the cop said you're being detained for obstruction. If I was the judge, I'd say, well, okay, well, hold on a second, dude. I'm not looking at a resisting arrest charge right now, even though in my mind that's what's happening. You're saying that he's obstructing. So therefore, I'm only seeing one offense right now, not two.
You need to set the phone down on the hood.
I'm a constitutional law scholar. You can't take away
Set
my
the phone down on the hood.
I'm now.
You're being detained.
Okay, take a look at the left hand of Chillie. He kind of moved the cop's hand back. It looked like to me, which would be a battery on a peace officer. Understand that battery does not have to be painful. It can be just any unwanted touching, you know. And I mean, just ask Joe Biden what a battery is, you know. It's not D batteries. It's not C batteries. It's sniffing a girl's hair. She didn't want you to do it. That would be a battery. An assault would be like pulling a gun out on somebody and threatening them with the gun without saying a word, or pulling your fist back or pulling out a knife. That's an assault. You put someone in fear of a dangerous touching, fear of injury. A battery is the completed assault. You fire the gun and you hit them with the bullet. There's the battery. This guy touched the cop. That is a battery charge.
You're going to put hands on me?
No,
Come over.
The cop's reaction is what's called an excited utterance in court. It's a hearsay exception. It is allowed in evidence. Watch him grab Chillie.
Over here.
Why are you grab?
Now, this is what we call being able to smell someone's breath. I want to show you this because he's going to get very close to Chillie's face.
Why are you
Almost like they kind of like touched heads there.
grabbing me?
And he's kind of ragdolling Chillie right now. Now, for our own private gag reel, because it has to be funny, let's watch this in slow motion. The face on Chillie when he gets to that romantic encounter.
Officer Bork, you're being detained for obstruction. You need to set the phone down on the hood.
I'm a constitutional law scholar.
He is a constitutional law scholar.
Set the phone down on the hood.
That's obstruction.
You're being detained. You're gonna put hands on me. Come over.
Okay, so one hand on the chest, another hand on the arm, and he's going to pull him close. Watch the face of Chillie, guys. It is funny.
Over here.
Why are you
The cop has really very little trouble manhandling Chillie.
grab?
That to me looks like they bumped heads, you know, in a rather interesting embrace. Because watch how Chillie's eye closes.
What?
Let's just watch that again while I shut up. That is pretty funny.
I'm a constitutional law scholar. You can't take
Set the phone down on the hood.
I'm now.
You're being detained. You're gonna put hands on me?
No.
Come over here.
Why are you
Okay, here's where liftoff occurs.
grab? Why are you grabbing me?
Come over here to the car.
Sure.
You,
Let it
come
roll.
over here.
Let the phone roll.
I don't care about the phone.
Why are you grabbing
Turn
me?
around.
I'm a
Turn
member
around.
of the press.
Turn around.
I'm not doing anything.
You're being detained right now. Turn around.
Get your supervisor.
Stop.
Hold on. Wait.
Stop.
Are your cameras on? Are your cameras on?
Yeah, it's on.
Okay, then
Put your
don't
hands
put me
behind
in
your
here.
back.
No.
You're going in handcuffs.
Why?
Put your hands behind your back. No, that's not obstructing. That's resisting arrest. And now he's got 2 cops on him. Now, when the cops keep telling him to put his hands behind his back and he says no, that to me, it's either going to be obstruction or it's going to be resisting, depending on the context.
Put your hands
Why?
behind your back.
Can we slow down? Get a supervisor. I haven't done anything wrong.
Put your hands behind your
haven't
back.
done anything wrong.
Don't make
This to me would be resisting arrest.
me use some
If you want to
tactics on
detain me, then detain
I am
me
putting
here.
you in handcuffs.
But I'm not putting my hands behind my
You're
back.
facing the hood.
I'll
Turn
face the
around.
hood.
Policy to put it behind.
Don't
Listen.
Be behind your back.
Right now, you're going to get a ticket.
For what?
Now, here's where Chillie could have been a lot smarter about this. The judge, the cop is saying, give him a ticket and let him go. But Chillie's not letting that happen. Chillie's trying to turn this into a full booking by just becoming more combative.
You do not put your hands behind your back. You're going to jail. Put your hands behind your back.
Can I turn my
Do it
camera around
now.
and face me?
No.
Can we agree on
No, I don't know if you have any weapons.
I don't have any weapons.
Stop reaching.
There's no weapons on me, guys.
Stop
I'm a journalist.
reaching.
I'm a constitutional law scholar. You extended
Listen.
a stop to
Put your hands behind your back or you're going to jail. I'm placing you in handcuffs right now.
for what
Turn
reason?
around.
For what reason? These are all obstruction, delaying tactics. And refusing to put his hands behind his back to me would be resisting arrest.
For officer safety, right?
Turn around for officer safety.
Is the camera still running, guys? The camera's still running.
I
I'm
don't
facing
care.
your car
I
like you're
don't
asking me
care.
to do.
I don't care about the camera. Put your hand behind your back. Do not reach for this phone. Hey, back up.
So I saw earlier when I was trying to turn my body camera off to call Sergeant Torrey out of earshot from this person, that while he physically was pulling away from me, it had turned the power button off. I'll show you here. There's a power slider on the bottom here. Let's see. Where it's blinking red, there is a power slider. And while he pulled away from me and was resisting arrest, he knocked the slider to the off position. So that's where you'll see the body camera had turned off. But I'm back on now. I'm going to keep it on the remainder of the stop.
Okay, so Chillie, so there's the resisting arrest charge according to the power slider going off on the body cam. If I was Chillie's lawyer, I would then say, okay, so the other things weren't resisting arrest, only this. So, by your own admission, the difference there is that it's calling for a legal conclusion. It's within the province of the DA to say, well, okay, the cop may have called it that, but I'm a lawyer and I'm saying that this is what he did. And the judge would still look at it as whether or not it was resisting or obstructing, but you can get around that pretty easily. Here, Chillie is saying the cops have small penises, they need Viagra, none of this shit's going to help them, just makes them look a rabble-rouser. And then there's a section where the cop gets out and then Chillie challenges it, says he's going to basically file a federal lawsuit against him.
Then the federal civil rights lawsuit before?
Yes, I have. Okay, well, I won that one. I'll win this one too.
You won't.
Okay, good luck.
This is wrong what you're doing to me.
A lot of people sue me,
You're
but
allowing him to torture me, dude.
okay, I'm going to work my narrative.
Serious reason.
So Chillie asked him, have you been in a federal lawsuit before? The cop says yes. And I won that one and I'll win this one too. And I guess supposedly he did follow through with some civil rights lawsuits. I've not seen it, but I heard that. I don't know if it's true. Once again, none of this would help Chillie if he would just stay quiet, because now all he did is put the police officer on high alert that everything now has to be thoroughly documented so that it doesn't get forgotten 2 or 3 years from now when the guy's deposed.
Did the same thing. I was just holding the handcuffs lightly, and he kept saying I was twisting them. And I was not doing an ignition lock, even though it is an improved technique. We were literally just lightly handling the handcuffs, touching the handcuffs. And he thinks that we're hurting him.
Chillie makes, I think, a terrible admission against himself that the prosecutor will seize upon.
My argument with you is that I feel like you picked about the poorest way to bridge the gap with police. If that was your intent, to bridge the gap, I think there was
1,000 ways that were better than what you chose.
The first year I tried it nice.
Right there.
The first year I tried it really sweet.
I tried it nice for the first year.
So nice, officer, corporal, lieutenant, sir. Can we have a meeting, sir? Please, let's get together and talk about this, sir. I did that for a year, dude. You know where it got us? Nowhere. Nowhere.
Okay, so this is a pretty fatal admission. If I was the prosecutor on this case, I would say, okay, since you did say that and it's a party admission, I'm going to use that against you. And secondly, that means after that 1 year self-imposed deadline is ended, now you're not nice. Now you're confrontational. Now you're combative, right? That's why you're there, to steer shit up, because no one will listen to you. Okay, fine. Well, that would lead then it naturally as an inference to obstruction and resisting arrest. Huh. What do you know? By the way, this almost looks like a Chick-fil-A sign, but I know it's not.
You may not know it, but
Good sandwiches, though.
I'm one of the most popular guys in the country who does this.
Chillie's mentioning how he's one of the most popular guys in the country.
And I tried to tell him, man, it's like, look, we don't need to do this. But we're still doing
Pleading
it.
his case,
I don't get it.
getting on his knees.
I would never take you to this place. You know that? I would never drag you off like this. And you saw my record. There is nothing.
He also said he doesn't have a criminal record. Is that true, guys? He says that the cops have small penises, small dicks. He talks about how he's an alpha male, they're beta males. He said that he was an executive and he took a big cut in pay to do this kind of work. He essentially, I think, is pleading with the cop to call off the arrest once the guy's in the squad car. And the cop says, nope, can't undo it. And Chillie's saying, we need to have this conversation. And, I'll give up my right to sue you. And then you don't arrest me. And then we can then have a discussion about, how far or how auditors should be, what kind of distance needs to be used. We have this conversation. And then he said something that was really telling in one of his videos. Looking at the charges he's facing, one is obstructing a public officer, the other is resisting a public officer. You can see, though, there's the common words you use: delay, delays, obstruct, obstructs, duties, duty. These are very vague, all-purpose statutes. Like I said before, they've already been declared constitutional. So for a constitutional law scholar, the trial court isn't going to care that he's going to make constitutionality arguments. He can only make those at the trial court level to save them for appeal. But if it goes to the first level of appeal, they're going to be forced to respect the view of a high court that said it is constitutional. So that appeal is wasted, lots of money. Now it goes to the Supreme Court. They're like, I don't know that we need to review this. We've already made a decision on this. We've already said it is constitutional. Then he's got to find a way to angle it into the federal Ninth Circuit, which has said, no, we don't agree with you. So we're talking a lot of money to try to overturn this law. So every person who, after due notice, so they have to be on notice, it can't be secretive, and a police officer uniform is notice, shall refuse. That's intentional. Or neglect. That's negligent. Intentional, negligent doesn't matter. It's swept in. To make or furnish a statement, report, or information lawfully required. At this instance, all he was asked for was a driver's license. Social Security not necessary if you give him a driver's license. The cop passed on that one correctly. It says, or who in such statement reporter makes a willfully false, untrue, falsely misleading, falsely exaggerated statement, or who willfully hinders, delays, or obstructs a police officer in the discharge of official powers or duties. Misdemeanor. So the obstruction could be refusing to cooperate. That's what I saw in the constitutionality case I showed you in the second video, where the guy was just basically being a jackass, obstructing the investigation, getting in the way of the questioning of the cop by the cops, by interjecting himself, saying my dad is a lawyer or whatever. Those would be obstructionist things. His refusal to be cuffed, that to me would be resisting. His making the cop put his hands on him and then breaking away, that would be resisting if that's exactly how it happened. With the body cam being deactivated because of Chillie, that could be resisting arrest. The failure to cuff up would be resisting arrest. When he says, no, you're not going to put your hands on me, that would be resisting arrest. So a person who in any case or any circumstance is not otherwise specially provided for, see, these are catch-alls, willfully resists, delays, or obstructs and attempting to discharge any legal duty of his or her office shall be punished. And number 3, when there's no weapon involved, no dangerous weapon, a misdemeanor. cop could say, one of my duties is to enforce the law. One of my duties is to put people in handcuffs. One of my duties is to apprehend people and to arrest them and place them in custody. And yeah, he interfered with my abilities to do this. He willfully hindered it. He willfully stopped. He willfully obstructed me. How many times I have to ask him, turn it around on his back, turn around and, put his hands around his back. So the statutes somewhat overlap, makes him dangerous. I say he will be convicted on both counts. This is not a legal prediction. This is just me looking at it. I'm obviously not giving legal advice. Maybe something will happen. Who knows? But as it sits here, from my perspective, after 10 years of doing criminal defense work and working as a former DA, I'd say they got a solid case here. The appellate panel in the Ninth Circuit. Now you're talking a ton of money, a couple $100,000. Look at the statutes, we can see that they have overlap. For example, they use the word obstruct in both a resisting and an obstructing charge. They use the word delays in both an obstructing charge and a resisting a charge. So we're going to watch the tape, and I'm going to talk a lot more than Chillie does. And one more thing, for a guy who talks about taking your Fifth Amendment and shutting up when the cops come up to question you, he sure does an awful lot of nonstop talking the whole time he's being charged. And so he gets the conviction, but he gets the chance to go in court and try to plead his case. And then if he loses, he gets the chance to now bring this up on constitutional grounds, which for a constitutional law scholar is the thing to do. The next problem I have, though, with the constitutional law scholar title that he gave himself is that it makes him sound like he has a law degree, or he's a law professor, or he's affiliated with some academic institution to be even calling himself a scholar. And, if I was the prosecutor on this case and I went up against a guy who gave himself the title as a constitutional law scholar, I would say that will make him get convicted more easily because he's now presumed to know the law, because after all, he's a law scholar. That will be used against him if the DA is watching this tape. That to me is a serious strike against him. Now, there's not going to be any jury. There'll be a judge. The judge will be the jury. I think the vagueness of the statutes is something that is not really before the judge. If you were to make an argument in your opening brief about the statutes being unconstitutional, all the trial judge can say is, I have to follow the law. And if the law is that it's constitutional, it's not my job to change it. You're going to have to take that up on appeal. Well, now he gets to the first level of appeal, which is the appellate court. And the appellate court says, well, the higher court above us says it's constitutional. So why should we change the high court? The high court's already spoken on this issue specifically. So then you bring it to the high court with a petition in Nevada. And they're saying, no, this doesn't change any settled area of law. In fact, our decisions are relatively recent on this. So no, now you got to look federal and try to jam this thing in front of the Ninth Circuit again, which has already ruled that it wasn't constitutional. And by the time you get to there, you've filed an appeal with the appellate court, a petition with the Supreme Court of Nevada, and now another round of opening salvos with. Let me try this.